Afternoon. Just going over a few things to look at, or at least one in this video, because I have an appointment coming up very shortly. But things to look at in your ALJ decision if you've been denied. Not to say you shouldn't look at it anyway. You want to make sure an award is done properly too, so that there's less risk later on. But one thing I would check, and this came up recently, and that's why I'm telling it to you. Towards the end, one of the last sections of the ALJ decision will include, generally, usually 3 occupations that the ALJ is finding the claimant could do. And the ALJ decides that oftentimes based on occupations that a vocational expert who testified at the hearing provided. And the VE did so after being presented with a hypothetical individual situation with a particular RFC, residual functional capacity. So when you, this is going to be difficult if you're not taking notes while you're at your hearing, and understandably you might not be. It's tough for the best of us, and we can then later get an audio copy of the hearing. I think you probably can too. You'd have to talk to the Office of Hearing Operations after and see how you can get a copy of the audio. I don't know how easy that is to transfer, given its size. Maybe they have to send it to you on a CD. I don't know how that works, because we get access through our attorney and non-attorney rep registration with our clients' cases with the SSA, and we get it through the online electronic records express. But I'm not sure how you would get that without having that kind of access. So, but once you get the audio, you can refresh yourself. You might want to listen to the hearing a few times. But one thing to look at is the jobs that the ALJ found you could do. Were they the ones that the vocational expert testified to at the hearing, or did they come from someplace else? Arguably, if they came from someplace else, that would be some other expert, maybe a vocational expert who the questions were sent to in written form sometime prior to hearing, but that vocational expert never testified. And the important thing about testifying is that they can be cross-examined, right, by you, or if you have an attorney or a non-attorney rep. So when the occupations chosen by the judge as the ones one could do based on some written report in the file, and disregards the occupations presented by the testifying vocational expert, the one that you would have cross-examined and asked further questions of, and well, would this job be possible if this was so, blah, 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 if the evidence showed this. So that is something, and because it just came up, it's very bizarre. It's something I think you always need to double check. Because I think it would be an appealable issue if the judge decides through some other expert that the claimant has not had an opportunity to cross-examine and flesh out that opinion, particularly one that's 2 years old. We'd like to think that would be a really strong basis of appeal to get at least a remand back. Now, just a reminder, oftentimes a remand back, that doesn't mean you won your whole case. That means you won your appeal, and your case is now going to go back to a place in the timeline, so to speak, before an ALJ hearing, so you get another hearing. And generally, that is with the same judge. That makes people really, really uncomfortable, I know. But in the instances where that has happened, I have not found the judges to be, unreasonable. I think sometimes, and it might even be where something got crossed in the mix, and they don't now, they might not agree with the previous denial. So I do find that they tend to reevaluate it all anew. I know there's cases I've heard colleagues of mine explain how no, it was just another opportunity to deny again. So I get that can happen too, but don't just assume that. I've seen many a judge, reverse what they did before or come to a whole different conclusion. Keep in mind, that's why it's very important after your first hearing, because you don't know what's going to happen, to continue treating. Because if you go back to that same judge for a redo, you're going to want to you want to show him that there's something he can pin it on, that might not be from what the evidence was before, because just because it gets remanded to him doesn't mean that the end decision was necessarily incorrect in and of itself or would have to be held that way. It could just be a technical thing he can then correct, and then he can come to the same conclusion. So you want to continue to build that evidence even after the first hearing. Don't just sit on your laurels and say, well, it's, the chips will fall. Not necessarily the case. But again, when they decide what occupations you can do, if you've been denied, double check and make sure that those are the occupations that the expert at the hearing testified to. Okay. Because I think that could be a very kind of straight up non-discretionary, perhaps, appealable issue to at least get another hearing and keep it alive. Okay. Yeah. Wish me well on this one. Bye, guys.